A legal English. Labor law. Labor law is the body of laws, administrative rulings, and precedents which address the legal rights of and restriction on working people and their organizations. As such, it mediates many aspects of relationships between trade unions and employers. Out of all different branches of law, this one deals with the terms and conditions of work and disputes regarding employment of labor. This is a set of rulings and regulations that govern the relationship and terms between employers and employees. In its most comprehensive sense, the term includes social security and disability insurance as well. In addition to the individual contractual relationships growing out of the traditional employment situation, labor law deals with the statutory requirements and collective relationships that are increasingly important in mass production societies. The legal relationships between organized economic interests and the state, and the various rights and obligations related to some types of social services. The basic subject matter of labor law can be considered under 9 broad heads: employment, individual employment relationships, wage and remuneration, condition of work, health, safety and welfare, social security, trade unions and industrial relations, the administration of labor law, and special provisions for particular occupational or other groups. There are special rules about the employment of children and young people. Your rights at work will depend on your statutory rights and your contract of employment. Statutory rights are legal rights based on laws passed by Parliament. Nearly all workers, regardless of the number of hours per week they work, have certain legal rights. The contract of employment is the agreement made between the employer and the employee. This could be in the form of a written agreement or what has been agreed verbally between them. In addition, the contract of employment will also include custom and practice agreements. These are how things are usually done in the workplace. For example, if an employer always gives employees a day's holiday in August. Even though this is not mentioned in the written contract, this will form part of the contract of employment as it is usual practice. If a written contract says one thing, but in practice all the employees have been doing something else with the employer's knowledge and agreement, the custom and practice would form the contract rather than the written statement. A trade union may have negotiated an agreement with an employer about conditions at work. The negotiated agreement will often form part of the contract of employment, particularly if the conditions are more favorable than the previous one. One of the main functions of trade unions is to protect the rights of workers. All workers, regardless of the number of hours they work per week, are entitled to receive a written statement from the employer within 2 months of starting work. The statement describes the main terms of the contract of employment. The statement must give details about job title, wages and hours of work, sick pay, pension schemes, holiday entitlement, grievance dismissal and disciplinary procedure, and so on.